If you filed a long-term disability claim, receiving a denial letter can seem devastating. It often feels like a final no, but that letter is one of the most important steps toward getting the benefits you need. If your claim is governed by the federal law known as ERISA, insurance companies are required to provide you with a detailed explanation of why they denied your benefits. Rather than a dead end, you should view this letter as a roadmap for your appeal. Hi, I'm Leah Small, a partner here at CCK Law, a nationally leading public interest law firm based in Providence, Rhode Island. Today, I'll be discussing what a long-term disability denial letter must legally contain under ERISA, common red flags, and how to use that letter to build a strong appeal. Before we begin, be sure to like this video and subscribe to our channel for more LTD content. Under ERISA, there's several things a denial letter must include. It must include the specific reasons for the denial. It can't just say, you aren't disabled, but it must explain the logic behind the decision. The letter must also reference the specific policy provisions, such as the definition of disability, on which the decision is based. It must also include description of any additional material needed for your claim. This means they're required to tell you what information is missing and what is necessary to perfect your LTD claim. The letter must also include an explanation for disagreeing with or not following the views of your treating physician or disability determination made by the Social Security Administration. Finally, the letter must also include an explanation of the appeals process, including any deadlines, as well as a notice of your right to the claim file. When reviewing an insurance company's denial letter, there are several things to look out for. First, you want to look out for the insurance company cherry-picking medical evidence, such as highlighting one good day in your records while ignoring months of documentation showing significant symptoms and resulting limitations. You also want to keep an eye out for the insurance company relying on file review opinions over your treating doctor or using the wrong job description when determining whether you're disabled. You should also look out for the insurance company taking surveillance or social media out of context, such as looking at a photo of you carrying a grocery bag and claiming it proves you can work a 40-hour work week. Additionally, you want to keep an eye out for the insurance company failing to address subjective symptoms, especially for conditions like chronic pain, fatigue, or depression. If you receive a denial letter, you should request the claim file from the insurance company. This file includes all documents, records, and other information that was relied upon in making the decision or that was submitted, considered, or generated in the course of making the decision, regardless of whether those documents were relied on. For example, the claim file lets you see any internal medical or vocational reviews the insurance company obtained as part of its claim review. You should treat the denial letter as a roadmap. This includes gathering any missing evidence the insurance company identified immediately, as well as gathering detailed evidence that rebuts their purported bases for the denial. If you need help with your long-term disability claim or appeal, then we may be able to assist. Since 1999, we've been helping claimants get the benefits they need. We've gone up against all the big-name insurance companies and know how they operate. You can reach out to us anytime for a free case evaluation, either by phone or via an online form on our website. If you found this video helpful, then be sure to give it a like and subscribe to our channel for more LTD content. Take care.